Good afternoon, everyone, and welcome. And thank you for coming to our program. It's called Defending Immigrants, Impact of Crime on Immigration Relief. And we are co-sponsoring this CLE with the criminal section of BHBA. And before we begin, we have a few housekeeping announcements. You will receive your MCLE certificate shortly after the program. And your certificate will also be your BHBA in your BHBA Plus members only community in your profile. So when you get it, please take a moment to complete the survey that is included with your certificate. And now my co-chair, Maggie, will introduce our speakers. Muted.
All right, my first time on Zoom, hey? Hi, everyone. Welcome. I'm Maggie Stewart, the co-chair of the immigration section. We thank you so much for joining us for today's CLE. I am really honored to be sharing with you all today a presentation by Judith Wood. If you do not know Judith Wood, she is a 35-year attorney working in the immigration nexus here in Los Angeles. She is a frequent presenter at AILA. Her office caseload, as far as I read online, was sitting at around 6,000 files. So if you are feeling overwhelmed at your office today, Judy's is probably got more. And apparently she estimates that up to 75% of her clients are women. She works in asylum and deportation defense, family visas, immigration options for victims of crime, and all other areas of immigration law. She has shaped immigration law with her cases in the United States and has made such a notable contribution to immigration that, in fact, a movie was recently made about her called Saint Judy, starring Michelle Monaghan. So go ahead and check that out this weekend. It's on Netflix. I'm also glad to welcome our host and moderator for today's presentation, Qiang Bjornbak. She has been working as an attorney in California for nearly 20 years. She is the principal and founder of the law offices of Qiang Bjornbak and provides legal services in U.S. immigration law, China entry and exit law, and U.S. civil litigation. She has also handled hundreds and hundreds of cases including but not limited to asylum, withholding of removal, adjustment of status, naturalization, all forms of work permits, and investment visas. She has been invited to speak by the American Bar Association, the Los Angeles County Bar Association, the California State Bar, and other entities on immigration law and Chinese law. And so we have a real powerhouse experienced team to host our CLE today. We're so honored to have you both. Thank you for making time to join us. I know you both have very busy schedules. And with that, I'm going to turn things over to Qiang and Judy. Have a great day.
Well, first of all, I want to say thank BHBA to provide such a wonderful opportunity to us, and also want to express my heartfelt thanks to Judy Woods and Maggie and Joanne. So it's an interesting topic. You know, it's a combination of criminal defense issues and immigration law practice issues. Judy and I always run into some clients that have a combination of both issues and how we deal with that. I just give you a snapshot before I switch topic to Judy. And so in this seminar, you will learn what are the differences between inadmissibility and removability, what are the waivers to inadmissibilities and removabilities. That means inadmissible, that means, you have certain grounds that prevent you from obtaining any legal status in the United States. Removability means you have obtained certain kind of status, and however, because you committed crime, and then the government want to remove you from the United States. And Judy will also explain at the length about the concept about the aggravated felony and particularly serious crime. She's going to quote some case laws, And hopefully I just hope the audience can take notes about that because it's really important. And also there is a case law from the US Supreme Court, and the attorney, the criminal defense attorney, need to advise the his or her client the immigration consequences if he or she admits guilty. I do see, and there is a pattern of such practice in the criminal courts in California. So, and then also I welcome an audience to post as many questions as you want, because Judy and I can answer your questions. Okay, so let's invite Judy to discuss about the topic. And Judy, here's your floor.
Okay, thank you so much for having me speak to this audience. I think it's very important. Can you hear me?
Yes.
Okay. Before I even start on the handouts and the program, I'd like to just give you two examples of cases where, because it has there's a very human element to this whole area. A case that I'm working on now, a gentleman from Mexico, many, many years ago, 20 years ago, he was at a party and he shot a gun up into the air. The bullet never hit anybody, but nevertheless, he was put into proceedings. This was 20 years ago, and the laws have changed radically since then. And he left the country because he didn't want to stay in detention while the case was being litigated in immigration court. And consequently, he re-entered the United States and then was put into what's called removal proceedings. So I want to give you a context of where his case goes. And his case is coming up actually on Tuesday. It's gone through the federal courts, now it's back to the immigration court. He came back to the United States. Now, when someone has been deported and then they re-enter the United States, which is common in the criminal immigration context, they're only eligible for what's called withholding of removal. And they have to have what's called a reasonable fear interview when they re-enter. And if they pass that reasonable fear interview and they're able to assert that they actually would be persecuted in their home country, the asylum officer can then put them in removal proceedings. So with this particular individual, what happened was he was in removal proceedings. We had the hearing. Everybody testified. A number of members of his family were killed, raped, tortured in Mexico. And so that was basically the basis of his withholding claim, because in order to win a withholding claim, you have to prove that you would be persecuted on one of the 5 grounds: race, religion, particular social group, nationality, or religion. And so what's at stake now is proving that he would be persecuted basically on the basis of a particular social group. But the first threshold issue is whether or not that crime that he committed 20 years ago is in fact a particularly serious crime. So the judge has asked us to brief that. It went up to the Ninth Circuit, and the Ninth Circuit found that the judge had not done the proper analysis. There are several cases about how the judges have to analyze whether a crime is a particularly serious crime or not. And a particularly serious crime conviction, a holding by a judge or the Board of Immigration Appeals, precludes the respondent from applying for almost all forms of relief. He would not be eligible for withholding, asylum, or anything else. The only avenue of relief available to him would be under the Convention Against Torture, deferral of removal. And in that case, he'd have to prove that the government of Mexico is actually more likely than not to torture him. So it went up to the Ninth Circuit, and the Ninth Circuit remanded, saying that the judge had not done the proper analysis. It's a Francesco and QT-MT analysis as to whether or not this was a particularly serious crime. And so now we're back in court on that issue. It's kind of an escalator case. And this person actually is a very good person. This happened so many years ago. He's married to a U.S. citizen. He's raised her son. He has not had any other conviction. So you see how human the situation can be. If he's deported again, he'll be separated from his family. He's worked. This was just a mistake that he made in his youth. that's one human situation that I want you to know about before we even get into the fabric of all the laws, which keep changing, by the way. Another case that I recently was able to prevail in was a woman from Iran who actually committed welfare fraud, and she obtained quite a bit of money. And what happened was I got the case continued for several years. And so I got it continued. And after 15 years, if there's a 15-year time gap between the commission of the crime and when you're applying for a waiver, in this case, it was a 212H waiver, the person can actually get that waiver and get their green card, and she did. This woman was an elderly woman. She had cancer. She had stage 4 breast cancer. She had children here, US children here. And the judge was very, very kind and granted this woman what's called LPR status, lawful permanent resident, granted the 212H waiver. So I just wanted to give you a context of the human situation as it evolves in immigration court. So how does someone wind up in immigration court in the first place? Usually there are three routes to finding yourself in removal proceedings. You can have overstayed your visa, whether it was a visitor visa or a student visa or an e-visa or any other number of non-immigrant visas, or you can have committed a crime, which is basically what we're going to be focusing on, or you could just come through the border and ask for asylum, or you can have made an affirmative asylum case at the service center and then had the case referred to immigration court. So we're going to deal with the situations where people have committed a crime and they find themselves in what's called removal proceedings. Usually the crime is either a crime of moral turpitude, which makes them removable, or it could be an aggravated felony or a particularly serious crime. Now, an aggravated felony is considered a particularly serious crime, which bars the person from most forms of relief, as I said before. But a crime of moral turpitude, you are still eligible for several forms of relief. Now, you can be a resident, a lawful permanent resident, that is, you have a green card, and be convicted of a crime involving moral turpitude, and you might be able to keep your green card if you have been lawfully in the United States for 7 years and you've had your green card for 5 years. In those kinds of cases, you have to file a form, it's an EOI 42A, and show that the person has been here the requisite number of years and the requisite type of status. And the requirement for showing extreme hardship is not required when someone has a green card already. But it always helps to show that the family would suffer. Usually there are other family members involved. And also that the person is a relatively good person and doesn't have, hasn't been convicted of an aggravated felony. Now, what is a crime of moral turpitude? That's a very litigious issue, and the lead case on that is Silva Trevino. The cases keep evolving. What is a crime of moral turpitude? It involves reprehensible conduct, culpable mental state, something you've done something that's inherently base. And there's a whole, slew of cases, which I'm going to go over with you, as to whether something is considered a crime of moral turpitude or not. But if someone has been convicted of an aggravated felony and they have a sentence of 1 year, they're no longer eligible for what's called cancellation of removal. They're not eligible for cancellation of removal, either as a lawful permanent resident or someone who is not a lawful permanent resident. Now, the other form of cancellation of removal is for someone who does not have a green card, but they've been in the United States for 10 years at least, and they might be eligible if they have either a citizen parent or a citizen spouse or citizen children, or any one of those categories of people have green cards. In that context, those cases usually arise when someone has been in the country for a number of years and then commits a crime, but they have a family member who will suffer extremely unusual and severe hardship should that individual be removed from the United States. And what is severe and unusual hardship? That varies from case to case. If the person has a mother, father, or wife or children who are severely disabled or suffer from some sort of mental incapacity or even a learning disability. A lot of, in many of these immigrant cases, their children have a learning disability. You might be able to prevail in that type of case, even if the person has a crime, but it cannot be an aggravated felony, because the aggravated felony bars them from all kinds of relief. But if it's just a crime of moral turpitude, they might be able to get a green card if they can prove that there would be extremely unusual and severe hardship to the qualifying relative. Now, if someone already has a green card and they've left the United States and then they're apprehended at the border, they can request a 212H nunc-pro-tunc waiver. Let's say they have had a crime in the past and they haven't been detained or apprehended, but then they traveled and they left and then they came back to the border. That person can be put in proceedings and they have to file what's called a nunc-pro-tunc 601 waiver.
Judy, let me stop you right here. So if this is the situation, so he committed a crime in the United States, was convicted, and they left the United States and came back without being caught. How do you deal with that?
If they left the United States and came back without being caught, you might not have to deal with it at all. It's only if they're caught and put in proceedings. That would only come up in the naturalization context.
Mm-hmm.
If they're not caught and they're not in proceedings, you don't have to deal with it. It would only come up if they're in a naturalization interview and they give a misrepresentation and say they were never arrested. Then you'll have to deal with it. And that often happens. People apply for naturalization and all kinds of things come out that were not obvious before. And that's why you have to be very careful before filing for a naturalization, before filing to become a US citizen. In that context, I would like to spice these talks up with real cases. I have a client who actually committed fraud in obtaining his lawful permanent residency. He filed a frivolous asylum case when he first came to the United States. He used a different name, a different country, a lot of fraud in his case. And then he was denied asylum, and then he married a US citizen and he applied for a green card through the US citizen and got it. Nobody noticed, nobody at the service noticed that there was a prior deportation issue with him. And then when he applied for naturalization, everything came out, and now he's in very difficult immigration proceedings. And that situation is so tragic because the wife is really dying of breast cancer now. She's had stage 4 cancer for a while, and they have a child. And so it's so tragic. I mean, these people, and often these people have actually good asylum cases, like they've really been persecuted, but they encounter someone commonly referred to as a notario who has a prefabricated asylum case for them, and they file that, and then that's called a frivolous case. And so even if the person had a really good asylum case, their fraudulent asylum case bites them in the foot, and they're no longer eligible for anything, because if the judge finds that they have filed a frivolous asylum case, they're no longer eligible for any form of relief under the Act. The only thing that remains open to them is relief under the Convention Against Torture, which is a hard thing to prove, that the government, wherever they're coming from, would actually torture them. If they've been tortured in the past, it might be possible to win under Convention Against Torture, but it's still very difficult. So moving on, how does someone find themselves in removal proceedings? Well, usually the people who find themselves in removal proceedings who've committed a crime find themselves in a situation where they're detained at one of these detention centers throughout the country. There are two types of people generally that are detained. One is that the arriving aliens, people who come through the border, they pass what's called a credible fear interview, or people who've been in the United States and they're arrested and then they are put in proceedings. And in order to bond them out, we have to prove that actually they're not a danger to the community and there's no risk of them absconding, that they'll actually go to their hearings. So once they're in the hearings, there's a lot to do, quite a bit. The 212H waiver is very, very interesting because people can get it to, yes?
Can you give us a detail of different kinds of waiver?
Well, there's a 212H waiver, a 212C waiver, a 601 waiver. There are many types of waivers available to immigrants. And also there's a 237 waiver. The 237 waiver has to do more with fraud than with crimes. But I'd like to talk a bit, if I may, about the particularly serious crimes. And I have prepared a list of cases because that holding particularly serious crime is so serious that it's constantly being litigated. What is a particularly serious crime and what is not? So I'd like to go over that for a moment, if I may.
Sorry to interrupt, Judy. Is that slide 8 in the? We just want to make sure we catch up the slideshow to where what you're referencing. We'll catch it up to slide 8.
Yes.
Okay, perfect. Thank you. Sorry to interrupt.
And Judy,
Okay,
you want the BHBA to post your particular serious crime documents on the chat?
Yes, I put in some case law. So a particularly serious crime, in the analysis, the judge has to look at the nature of the conviction, the circumstances and underlying facts of the conviction, the type of the sentence imposed, and whether the circumstances of the crime indicate that the individual will be a danger to the community. So if the person is considered a danger, if it's considered a particularly serious crime, the person is immediately considered a danger to the community, despite the facts, like in the case that I told you about at the very beginning, the gentleman from Mexico who came back to the country and now raises a family here. And this happened so many years ago. He's not a danger to the community. Nevertheless, the judge may find that it was a particularly serious crime, no matter how long ago it happened. And we're arguing that it shouldn't be considered a particularly serious crime, but I guess we'll see what happens in court. Controlled substance trafficking is presumed to be a particularly serious crime. Crimes against people are considered, which is a crime of violence. If you've hurt someone physically, that's considered a crime. Also, if the sentence that has been imposed is 5 years, that's considered a particularly serious crime. However, if the sentence is less than 5 years, the judge can still find that it's a crime, that it is a particularly serious crime. And so it's extremely important in this context to argue that whatever the crime is, it is not a particularly serious crime. Otherwise, your client is really precluded from most forms of relief. And I'd like to go through some of the case law because I prepared it. So a person convicted of particularly serious crime is considered per se to be a danger to the community. And a case on that from the Ninth Circuit is Gomez-Sanchez v. Sessions. Site is 892 F3rd 985. 9th Circuit 2018. This person was asking for withholding of removal, but it is the court held that it irrebuttably presumed that once a crime is determined to be particularly serious, the person who committed the crime presents a danger to the community. So that's the problem. Even if it happened 20 years ago, the person is still considered a danger to the community, and the court finds that he's not eligible for protection by this country from persecution in another country. But there's another prong to this. Even if it's not considered a particularly serious crime, for purposes of withholding of removal, you have to show that the person would be persecuted on account of one of the 5 grounds, as I said, race, religion, particular social group, nationality, or religion. So that's another hurdle to jump through. And your client may or may not be able to prove that, even if you're able to prevail and that it's not a particularly serious crime. So the standard for determining whether that is a particularly serious crime is matter of Frantescu, and there are 4 factors. Also, QTMT is an important case in this: the seriousness of the crime, the nature of the conviction, the circumstances, the type of sentence imposed, and whether the circumstances indicate that the person would be a danger to the community. So all aggravated felonies, in other words, if someone has a conviction for 1 year or more, are considered particularly serious crimes. So you can see that creates a tremendous obstacle for someone to stay in the United States once they have that type of conviction. there's an important Ninth Circuit case, matter of, it's called Blandino Medina v. Holder, which says, for purposes of an asylum case, an aggravated felony is per se a particular crime. However, for withholding, which is different than asylum, you can show that there might be circumstances where they might be able to still get withholding. So what's the difference between asylum and withholding? If someone has an aggravated felony conviction, they're definitely not eligible for asylum, but they still might be eligible for what's called withholding of removal. What's the difference between asylum and withholding? In asylum, if someone is actually granted asylum, political asylum or whatever kind of asylum, people refer to it as political, but it can be religious asylum or asylum based on membership in a particular social group. You are, in 1 year, you're able to adjust status to become a lawful permanent resident. There are also many other benefits. It is a road to citizenship, and you can also bring your family here if your family is overseas. Even if your family is here, you can bring them in. For instance, I have a case, an interesting situation. Besides the particularly serious crime, which you can see from what I've already said, it's a bar to most forms of relief. If the judge finds that you filed a frivolous asylum case, there's a bar to relief. But I'm currently litigating a case where the person was found to be frivolous, but his wife was granted asylum. His wife was granted asylum, and they come from the same country, suffered similar situations. We were able to go to the Ninth Circuit and get the frivolous finding reversed. He's not frivolous anymore. It was just found to be not credible. When not being credible is not a bar to relief, you can still win, maybe. And so his wife got asylum, and then when the spouse gets asylum, it's a big benefit, because what she did, she filed a 730, which is a following to join asylum case for him, and so now he is considered a refugee. And so we're trying to get the Ninth Circuit. Well, the Ninth Circuit has granted what's called judicial administrative closure to give us time to work it out with the Department of Homeland Security in order to get him adjustment of status, because now that he's an asylee, it's possible that he can adjust status. So you can see the benefits of being granted asylum are tremendous. You can get a green card, you can become a citizen, and you can petition for your family. Now, let's say someone has been granted asylum in the past, and then they commit a crime. They can be put in proceedings again, and there's a waiver. It's called a 209 waiver, and they have to prove hardship to the family and what would happen to everyone if that person was deported. And there are people who are in immigration proceedings that can continue to commit crimes, especially drug-related crimes. And so that really makes it difficult when you're litigating in front of an immigration judge who's found that even though the person was granted asylum and then perhaps even in the past granted a 209, I'm only talking about this because it's a real case we're working on, later granted a 209 waiver, based on a crime that he committed, and the lead case on this is matter of Jean on a 209 waiver. That a 209 waiver for someone who's been granted asylum, but then they commit a crime, and that's another waiver, 209 waiver. So moving on, the Attorney General may determine by adjudication that a crime is particularly serious, even though it's not an aggravated felony. So even though the person has not been convicted of an aggravated felony, maybe it was a DUI conviction, the judge can still say that it's a particularly serious crime and therefore he's not eligible for forms of relief that might be available. If someone has the two bars here, the particularly serious crime and having filed a frivolous asylum case, leave open one avenue of relief. And that is under the Convention Against Torture. The Convention Against Torture is not part of the Immigration and Nationality Act. It's a UN document, the United Nations Convention Against Torture, meaning that if the person is going to be sent back to a country where it's more likely than not that he or she will be tortured, the government, the United States, is precluded from sending him back to that place. So that's hard to prove. You need a lot of documentation as to why that person might be tortured, and they have to have been, you have to fear torture at the hands of the government, or what's called acquiescence of the government. In other words, perhaps the government will turn a blind eye and allow the person to be tortured and not step in and try to protect him. I have an interesting fact scenario where a person was convicted of a particularly serious crime. It was a drug crime in the past, and we have filed an appeal for what's called deferral of removal under the Convention Against Torture. Under the Convention Against Torture, there are two forms of relief: withholding of removal, and which is different than the statutory withholding of removal, and deferral of removal. In both cases, you have to prove that the government is more likely to torture the individual. In that case, it's a very interesting fact pattern. The person comes from a country which has a high rate of crime, very high rate of crime, and he was very, very instrumental in helping the Los Angeles Police Department stop gang activity in Los Angeles. And so his crime, his drug crime, happened many, many years ago. And in the ensuing period, maybe 20 years, he's become a rather upstanding citizen. In fact, very much helpful to the law enforcement agencies. Nevertheless, the judge found that he was guilty of a particularly serious crime. It wasn't only the drug conviction, but he was also rather violent toward an individual on the street when he was younger. And even though he's reformed, the judge found that he was not eligible for anything except deferral of removal. And he didn't find that it was more likely than not that the person would be in fact tortured in his home country. So that's on appeal with the Board of Immigration Appeals. We'll see what happens. And all reliable information may be considered in making a particularly serious crime. In other words, the judge can look at police reports, sentencing information, any information that is in or outside of the confines of the record of conviction. So really, it's an open field for the adjudicator. The applicant's
so I believe, Julia, let me stop you right there. So that's why that shows your expertise. And so if anyone has a client who has committed crime that is considered to be, or likely to be a crime of particular serious crime, you need some lawyer like Judy and me and somebody else to defend this client in the immigration court. Go ahead, Judy.
Okay. So also the applicant's own testimony may qualify as reliable evidence, and you can bring in as many witnesses as are available to show that this person should not be held to account for what happened perhaps 20, 30 years ago. So recent Ninth Circuit cases involving particularly serious crimes are as follows: Gomez Sanchez v. Sessions, 892 F. 3rd 985, 9th Circuit 2018, which overturned the BIA's finding that mental health can never play a role in a particularly serious crime. So that is important. Mental health is an issue. Maybe the person was not really capable of having criminal intent, and that can be used to defend the person. Usually in an immigration court hearing, if the person is not competent, you have what's called a MAM hearing to determine whether the person is competent or not. If the judge finds that the person is competent, it may be hard to prove that the individual had mental health problems. But the Ninth Circuit has said that that has to come into play when the judge makes a decision as to the particularly serious crime determination. And also in Marina v. Barr, a 2019 case from the Ninth Circuit, the court held that aggravated felonies resulting in sentences fewer than 5 years are not per se particularly serious. And that means that the judge has to make a case-by-case analysis, including sentence enhancements. So sentence enhancements are if the person perhaps did a particularly heinous crime but didn't get a 5-year sentence, but then later on gets an enhancement, like for great bodily injury, the immigration judge can, or if they violated their probation, the judge can. Now, that's a very important issue when they violate their probation. because many of these people are given a sentence that's rather generous. Like it might be that they have a sentence of 1 year, maybe, and they're on you know, on a spree, and then they commit another crime. So they're put in probation revocation, and that's when they get in a lot of trouble. That's what happens a lot with a lot of these people. I have a case where a young man actually was got a really good, generous sentence from a criminal judge, from a criminal court judge, and gave him probation and allowed him to attend a drug rehab place. And unfortunately, the young man left the drug rehab place, and because he left the drug rehab place and came back, the drug rehab place was in another state, and he came back to Los Angeles. Because he came back and actually went to the judge and told him, look, I'm here and I want to, you know, start afresh. Can you put me in another rehab? The judge said, no, you left that, and then I'm resentencing you. So now he's in detention, and very hard to overcome that, because now the sentence is longer. And the immigration judge looked at the underlying crime, which was kind of violent action against his girlfriend. It was a domestic violence situation, and found that it was a particularly serious crime. So now this guy is kind of stuck, and he remains in detention while we try to prove that maybe he'll be tortured in his country, because that's the only thing that's left open to him. So moving on with these cases, Avendando Hernandez v. Lynch, the court said that they have the jurisdiction to review for abuse of discretion that the BIA's conclusion that an offense constitutes a particularly serious crime. So that the court can overrule the judge and the board's decision that it is a particularly serious crime. So that's nothing to overlook when you're litigating a case. Whenever you're litigating an immigration case, you have to, what I call is play to the Ninth Circuit, preserve your issues, so that when you're at the Ninth Circuit, you can definitely think about what issues you can raise. And let's say the person has committed a crime in his or home country. That will also trigger his inability to be granted asylum. It's not only crimes in the United States, but crimes which are not of a political nature in his or her home country. I'm currently litigating a case in the 10th Circuit on that, where the person was convicted of being involved in some sort of drug deal in Mexico. And although he contends that he's innocent, he pled guilty. And so we're dealing with a Mexican conviction, and now we're in the 10th Circuit. The judge, with the relief that might be available to him, is Convention Against Torture, because the cartel that threatened him is still alive and well, and still continues to threaten him and his family in Mexico. So we'll see what happens with that. Then a very, very important case, which is rather disconcerting, is Barr v. Barr, 9th Circuit 2020. And that says that the Board of Immigration Appeals can consider all reliable evidence whether a crime constitutes a particularly serious crime. So all reliable evidence, that lets in everything: consideration of conviction records, sentencing information, other information outside the confines of the record of conviction. So that's extremely important to take into account, because you have to look at everything that the government has and then try to refute it if it's possible.
Well, that's a very detailed information. I just want to invite Judy to talk more about the other aspects other than particular serious crime. And do you have any other topics that you want to share with the audience?
Well, I'm particularly interested in particularly serious crimes.
Oh, go ahead. Go ahead. I'd like to. Yeah, it's very interesting. Interesting topic.
Yes, yes. But I also want to talk about cancellation of removal, because that is something that's available to a lot of immigrants if they have 10 years here, and they haven't been convicted of what's regarded as an aggravated felony. I want to kind of talk about building that kind of case. Many of these people have children who have learning disabilities, and that is extremely important in the context of a cancellation case, because if you can prove extremely unusual hardship to that child, should he or she be separated from his parent. Now, the child has to be a US citizen, but if the parent is the breadwinner and supports the child both emotionally, financially, and in any other way, that child will be set adrift in this country without that parent. So if you're lucky enough that if your client is lucky enough that it's not an aggravated felony, you can get that person the ability to stay in the United States by having a grant of cancellation of removal be awarded to that person. I think we should go to questions. Let's have some questions.
Yeah, let me initiate some questions for you. I used to have this client, and then she applied for the asylum to the immigration consultant, and then she was accompanied to the asylum office by the immigration consultant, and then she lost. So she came back to the immigration court, and then the judge failed to give her the asylum warning. So when I took over the case, and then so I did argue.
You mean the frivolous one? Are you talking about the frivolous one?
Frivolous asylum, yeah. I did argue about frivolous asylum warning.
But the problem with that is it's on the form. It's printed on the form. Even if the adjudicator doesn't talk about it, it is written on the form.
But yes, but finally, but then anyway, the judge, I filed this case and appealed it to the BIA, and BIA granted.
Good.
The appeal, so I successfully arguing about she has no knowledge about the consequences of the.
Well, what was the nature? What was the frivolous? What was the nature of the frivolous finding?
Well, she applied. The nature is that she applied for asylum. She claimed she first going back to China, and then she later, when I took over the case, she married to a U.S. citizen, and the U.S. citizen literally has multiple medical conditions. Literally, so, and finally, she helped the husband to send her husband to hospital and save his life. So I did argue about that in the courtroom, and then the trial attorney was asking, oh, after you're married to your husband, do you want to go back to China? She said, yes. And then they say, okay, on your application, you say you're free to return and back to China. So what I did, I argued both the and lack of appropriate warning of the frivolous asylum, and then she also is eligible for waiver, and luckily, she finally got a green card after 8 years. Okay, fighting them
inside the United States or at the consulate?
Inside the United States, in the immigration court.
Because I have a case like that where the person filed a frivolous asylum case, really spun out of whole cloth, and then said it wasn't true, but the judge said, well, sorry, but you were given that warning at the interview because it's on the form. We have that on appeal as well, and she also has a sick husband. It's currently with the Board of Immigration Appeals, but the judge said, well, the trial attorney argued, and the judge agreed it's on the form. So what is a frivolous asylum case? That's an important distinction between something that's not credible and something that's frivolous. Qiang, would you like to address the difference between frivolous and not credible?
Well, not credible is, like you and I would know, that the clients probably will, sometimes, mostly under most circumstances, they cannot remember very well. So they have inconsistent statements. Let's say, the statement says, I met so-and-so XYZ day, and then they come to the court, testify that, or at the immigration asylum office, they testify they met someone at another date. So there are multiple inconsistency between the written statement and oral testimony. This is one thing.
But that's not frivolous. That's not frivolous.
Not frivolous. That's incredible. But frivolous, that means somebody give you the warning. You know that you translate it, right? You signed it, and then you still make a totally baseless, literally baseless. The story is fabricated. Let's say, somebody claimed, and I was persecuted because of one-child policy, all the stuff, but in fact, let's say you don't have this ground in China anymore because, let's say, the government allow you to have 2 or 3 children, right? So if you still claim it's one-child policy right now, it's frivolous. It's a frivolous. So that's the difference. It just one is a little bit inconsistency between the testimony and written statement, all the evidence. The, let's say, frivolous claim is totally the story is totally fabricated. Am I right on this issue?
So you think that if someone has a one-child policy, that's a frivolous case now?
Not necessarily. But
and under what circumstances is it not frivolous?
Well, it all depends when she claims it. Let's say if she claimed that the one-child policy issue a long time ago, it happened in China. So that's I call it non-frivolous claim. Now, if the new immigrant went to the immigration court, say, hey, you know what, the government forced me to have abortion because, it won't allow me to have more than 1 child right now. It's a frivolous because the policies in China have changed, right?
But what about a case where the person makes up a different name in a different country?
This not necessarily the frivolous, that's misrepresentation. Because, and I did argue about somebody got to flat the country, right? He or she has to use a false name to leave. And then so usually it doesn't constitute a bar. It is not a situation that you fabricated the whole story. It's just you use a fake name to leave the country. For example, somebody use a fake name to leave Russia right now. Do you believe that the person will want to fabricate a case if he, say Putin is really bad and get the pressure from the government, so he fled Russia right away? So yeah. I just don't think the use of false name is a frivolous asylum. Frivolous asylum means it's totally fabricated. There's no such thing. You fabricate the whole thing. So you don't have the persecution, but you make up the story in order to obtain the immigration relief. That's my definition.
What about 237 waivers? Those are interesting. Have you done any of those?
I did some of it, but I will let you talk about that. I will let you start the topic.
If someone has committed fraud in obtaining their green card, but then they're in proceedings, they can still keep their green card, actually, if they're able to show that there would be hardship to the family, that they're now like, yeah?
Yeah, I did that kind of case in the past as well. You have some, when including they use somebody else's passport came into the United States, and then the name, it doesn't match his real name or her real name. This is one issue. The other issue is that they lie to the U.S. consulate. They say, "Oh, I just want to go to the United States to have a, to have some sightseeing, or want to do some business." In fact, this is a false pretense, right?
But there's another issue. If someone obtained their green card through misrepresentation, and then goes to naturalization, and then are put in criminal proceedings because they obtained their green card through false pretenses, and perhaps went on to get naturalized even, and then get denaturalized, they're no longer eligible. There's the lead case on this, which grants actually 237, is matter of Agor. But if they're convicted in criminal court, federal criminal court, they're no longer eligible for a 237 waiver.
Well, the issue is that after they're denaturalized. Let's say if somebody was denaturalized, and then you lost your lawful status in the United States, right? So, and it will be an inadmissible issue, not a removable issue. Am I right on this issue?
Well, if you have this criminal, right, if you have the criminal conviction, you're inadmissible.
Yeah.
One other topic, though, is that I wanted to talk about was the 212C waiver. This was a waiver that was available before the IIRA passage in 1996 and 1997. And we actually still have a case that's pending now in court. It's an old form of relief. If someone had a green card, but then they were convicted of an aggravated felony, under 212C, you could still keep your green card. And if you won your 212C case, you could then naturalize. And the 212C required remorse and rehabilitation, even if you were convicted of an aggravated felony. And that's been wiped out. It's been replaced by EOIR 42A, which is cancellation for lawful permanent residence, which is not available to anyone who's been convicted of an aggravated felony. So the law has gotten far more narrow for avenues of relief, but there are still 212C cases alive and well.
That got to be very, the old cases. I had a couple of them, and about 15 years ago, I did it in the court, and it gets granted because. And I argued that that the person had been rehabilitated.
Yeah,
So
and you really have to show the rehabilitation and the remorse. Now, with one that I won a couple of years ago, the guy, he didn't really want to. He didn't want to express remorse. He felt that he wasn't guilty, but I forced him to, and he won. And now he's a citizen.
Oh, you did such a wonderful job. So let me see what the Q&A. Okay, what kind of question they have. So there's a question that I'm going to read it to you. If the immigrant who has been deported before and has a criminal charge not adjudicated in OC Orange County, he was working in injured with a brain injury and is under a conservatorship, if the DA will dismiss in the interest of justice in all cases, can he apply through any program to remain legally in the United States? He had a gun on the school grounds, possession of controlled substances while armed, and the possession of narcotics.
Yeah, this is serious.
He was selling drugs for cartel. He has been declared incompetent now, but wasn't in 1999.
Okay, well, I have an interesting case. It's not that different from this, where a guy was deported when he was a kid. He had been convicted of murder, actually. And then we got him back on a waiver. Matter of Veronica, you can get a non-immigrant visa waiver. He came back, and then when he was put in proceedings, and then the immigration judge terminated proceedings because I was able to prove that he came back to the United States legally and he was no longer deportable. However, the issue arises, how can he adjust status? His mother did petition for him, but it's much easier to get a waiver in a non-immigrant case. We were able to get him back into the United States than to get a waiver. I was just talking to the mother last night, in fact, to get a waiver on an immigrant case, because it's next to impossible when you have that kind of conviction. So this guy. Yeah.
Go ahead. Let you finish. You want me to ask you another question? So there's another question for you, is that in fact a couple of my friends and asked me to give them help. And there's some young students, and maybe they have violated their status. They work without authorization when they were in the United States, while they were students here. So, and they were barred from coming back for 5 years.
But that's not a crime. That's not a crime.
That's not a crime, but then are they, let's say if they committed a crime, let's say that DUI or driving without license or some stuff like that, okay, they won't be allowed to come back to the United States right away. And so if they still want to come back and they want to file a waiver with the consulate, of course, there is no form, and just, sort of kind of your declaration, right? And
well, if the person is married, if the student is married to you, a citizen, you can file, if they've been deported, you can file a 212 waiver. And if they have a conviction, you can file a 601 waiver at the consulate.
Right.
So if someone's been deported, let's say someone's been deported because they have a criminal conviction and they're already in their home country, but they have a US wife who'll suffer extreme hardship should they remain outside the country. You can file for the person to come back to the country by filing an I-130 and let it go through the visa processing process, and then file a 212 and a 601 at the consulate. It's very discretionary. You have to prove extreme hardship to the US citizen.
That's true.
But if there's no crime, they should be able to get a waiver if they're, but it always helps if there's a US citizen who's going to suffer some hardship. It's still possible to get it without a US citizen relative.
I have a question about that, what you were talking about, the 601, the extreme hardship, because I haven't done one of those. I did one years and years ago, and we had to prove like the American spouse was, you know, severely ill, and they had a US citizen child that was disabled and needed, you know, 24-hour care. Is that still the bar that has to be achieved? Like, because it has to be very high. I mean, the hardship is still very high, I'm assuming, correct?
Yes, it's a high bar, definitely.
And like, so if there's no, you know, other than like emotional distress of not being with your spouse or whatever.
No. You need the documentation. You need lots of documentation. That's what I know. Like a psychological report and doctors, you know, diagnosis or some stuff, you know. You have
But
to,
even with the medical documentation, depending on the severity of the crime, it might not be granted.
right. It's a discretionary relief. Yeah, I have this case which will just touch upon the particular serious crime that the client committed a rape, a minor. Okay, he raped the minor in the past, and he was sentenced to 7 years in the jail and 7 years probation. And he got out of criminal courts and then was put in removal proceedings, and I helped him. And it's just very hard to argue that it is not a particularly serious crime. And finally, I got him out of the immigration detention center by negotiating with the ICE officer and out of the humanitarian sort of kind of reasons. And he suffered from the lung problems, and so he got released. But he didn't get any relief. But however, he can get out of jail and stay at home.
Hi, we're running short on time. There's a few questions in the Q&A. Qiang, can you maybe bring those forward?
Let me read it. Okay, let me read it. So give me 1 second. What is the current policy on 2 or more DUI convictions?
Discretionary.
Okay. And another question, a LPR through marriage with green card expires. USCIS sent an extension for 24 months. At what point can she apply for the citizenship? Simple question, maybe out of the scope of this webinar.
If the person gets a green card through marriage, they can apply for citizenship within 3 years, actually 2 years and 9 months of having been granted the green card.
So in short, that it doesn't matter what the card expires or not, you just need to file the removal of conditional status.
Yeah, they have to file, right. And also in some cases they're divorced, if the people are divorced, you have to wait 5 years before filing.
Yeah. Any other questions from the audience? Oh, I just see another.
So this is an amazingly complex area, and the laws also keep changing because you have this interface between not only the different circuits, you know, you have all these circuits, but all the states have different criminal laws. So what's considered an aggravated felony here might not be considered an aggravated felony somewhere else. So it's extremely complex and requires a lot of attention.
Sure. I believe I cover all the questions. I mean, Judy covered all the questions. And any
no, I don't think we can cover this topic in an hour. Not at all.
Yeah, what about the time? It's 1:30 right now.
Judy, in your experience with the legalization of marijuana laws in so many states, and although it hasn't been, it's still illegal under, you know, federal law, has that changed at all? You know, whether people have been getting, because is it intent to distribute, you know, like has that changed at all in immigration?
If there's intent to distribute, you don't have a waiver because that's trafficking.
Right, but I'm saying, has the relaxation of marijuana laws in a lot of states had any effect in immigration consequences for marijuana? issue?
It's still evolving. I can't really give a complete answer to that. It's evolving.
Yeah, just to advise your clients not to
That it's
get
still a
involved
crime,
in
federal.
marijuana. Yeah, not
It's
to
federal.
involve the marijuana business. It's better. And the last question, Judy, on the chat box is that, how to deal with the dismissed crimes during the naturalization. Does the person still need to disclose that he has a case dismissed?
Oh, that's extremely important question. I just got a person naturalized who had a number of criminal convictions, but he was able to work all of that out, and he disclosed it all at his naturalization interview, and he's been sworn in as a citizen. You absolutely must come forward with all that information at the naturalization interview and on the form.
Yeah, and I want to emphasize that the same thing will apply when you apply for the green card. Let's say I have these clients who obtained the asylee status, and they consequently later they committed crimes, but the crime was dismissed. So when I applied for the green card for them and they went to the interview, they were required to disclose what's the results.
Because if you don't disclose it, it's misrepresentation.
Yeah. Finally, they got their green cards because I provided the records that all these cases have been dismissed. Okay, all right.
So we need at least 10 more hours for this conference.
I will do that again. Judy, you're wonderful.
You are too. Thank you, everybody.
Okay.
Thank you very much, Judy and Qiang, for joining us today. Thanks to everybody who joined us online for the CLE. Just a quick reminder, a pretty extensive PowerPoint presentation, as well as a document with all of the different cases that Judy's been discussing in these different issue areas, was circulated by email and was posted in the chat. So if you haven't had a chance to download those, please do. It's full of very really great resources that Judy's been kind enough to share with our group. So thank you, Joanne. Thank you, Judy. Thank you, Qiang. Thank you to everyone who's here and Beverly Hills Bar Association. Our next immigration section meeting is going to take place on April 8th, on Friday, second Friday of the month. And we'd also like to thank the criminal section for co-hosting today's event. So hope you all have a great weekend.
Thank you. Thank you, everyone.
Bye-bye.
Thank you so much.